And a lot of bouncing around here today in the trial of Kwame Richardson and Henry Hayes. The accusation here from the state is that they played a role in shooting that 22-month-old child. The intended target was allegedly a relative, and the child was shot and killed as part of it. This is sort of a tricky case, as we were saying before, because the juries are hearing the case separately. One jury for one defendant, one jury for another. It allows the witnesses to basically show up at court once. They just have to, at some points, repeat their story or only say certain things in front of one jury and only say certain things in front of another jury. The reason for that is to try to protect the constitutional rights of the defendants. We're going to talk about this for a little bit. Francey Hakes is with us on the line from Los Angeles. She's joining us here on the Law and Crime Network. Francey, good to see you again.
Good to see you too, Aaron.
Okay, so what do you make of this? I mean, some states would just say, okay, look, we're going to have two separate trials here. We're going to have the witnesses show up for one case, and then a jury will render some kind of a verdict, and then the witnesses will show up for another case, and then a jury will render some kind of a verdict. But here, they do this back and forth, bringing one jury out, sending one jury back in, and it results in sort of a disjunctive trial and a lot of breaks for jurors.
Yeah, Aaron, I mean, it's very disjointed. I'm not sure I've ever seen it done myself. I think I've heard of it, but I've definitely never had it happen to me. Generally speaking, co-defendants, those who have committed a crime in some way together or in concert, are tried together. Justice allows that. There must have been something in this case that made the judge very worried that certain testimony would be considered by an appellate court too prejudicial against the other defendant. But this is very unusual and very disjointed and difficult for a jury and even the witnesses and even the lawyers, because someone has to alert the judge when it's time for the testimony to take a turn to the other defendant. That means the lawyers have had to really prepare extra to figure out when those breaks have to be. It's kind of a bizarre situation.
It is, and I've seen this a little bit before in Florida, though, where this case is happening. Sometimes I've seen cases with 3 different defendants, and then you have 3 different juries. And you're correct. It results in a very carefully choreographed series of questions. And you heard at one point just a few minutes ago in the testimony, the litigants saying, well, Judge, this is probably a good time to bring in the other jury because we're done with this topic area. And the topic area was an identification. Now, certainly if I were defending one of these defendants who was not the one being identified, I wouldn't want him being tied into this crime, you know, sort of like, well, you know, he was with this guy and then this guy did it, and you wouldn't want that. So that's why I can understand keeping one of the juries out from hearing an identification that doesn't involve the actual client. But again, what I usually see is this being split up in 2 different trials with the witnesses just coming back. I realize it's probably more difficult for the witnesses, but it results in a trial where the jurors aren't just sitting in the back room or constantly coming and going, waiting for a certain piece of testimony to get wrapped up. You've got to wonder what the jury is thinking. They're only sitting in court for little snips here and there.
That's right, Aaron. That's the problem. You're actually not giving either jury the full story. To them, this has got to be a very confusing process where they're missing big chunks of the crime itself, what led up to the crime, and what happened after the crime when you're constantly having them in and out and only hearing certain things.
Yeah, we're going to get you caught up to speed on this case if you're just joining us here on the Law and Crime Network. This is the Florida prosecution of 2 men, Kwame Richardson and Henry Hayes, the victim, a 22-month-old child named Aiden McClendon. Let's get you up to speed on some of the facts.
Law and Crime now takes you inside the trial of the 2017 murder of a teenage girl underway in Wisconsin. 20-year-old Daniel Tate's accused of choking and drowning 17-year-old Olivia McKay in Lake Michigan. The two had met online. Tate's alleged to have arranged to meet McKay in a park in Kenosha County, Wisconsin, along with a friend. After Tate killed her, prosecutors say Tate and his friend put Olivia's body in the trunk of her car and dumped it in a rural area. Much of the state's argument in charging Tate comes from a confession of that friend, high school senior Jamari Cook, who claims he was there when Tate met with McKay and watched him murder her. Cook's expected to testify for the state, but the defense says he's not credible. Prosecutors say the defendant, Tate, had a history of choking women during sex and may call 3 witnesses who claim Tate choked them during consensual sex. Daniel Tate's charged with first-degree intentional homicide, hiding a corpse, and taking a vehicle without consent. I'm Dan Abrams for Law and Crime.
Those are the key facts there. We're going to be paying a lot of attention to this case, Francey. Just, again, sad facts, a lot of difficult testimony on the stand, and it just sort of gets drawn out by this process of bringing the jury back in and out.
It is, and you're right, Aaron. This is such a sad case. I was watching the testimony earlier today of the victim, little Aiden McClendon's mother and great-grandmother who were in the car when he was shot and killed, and having them talk about how they took him to the hospital, how they thought he was just sleeping, listening to the 911 call with the mother clearly in hysterics over whether or not her baby is okay. It was extremely difficult to listen to. Anytime you've got a child homicide case, it's hard for everyone involved.
It is, and a lot of the issue in this case is going to surround the testimony and the credibility of some of the witnesses, because you've got alleged gang members up there, and usually there are accusations of mistaken, not so much mistaken identity, but, hey, look, you have reason to lie on the stand. Who are you protecting? Who are you not protecting? Who are you trying to throw under the bus?
That's very true, Aaron. And it can be a case of mistaken identity. I mean, I'm certain that the defendants and their lawyers, as they cross-examine witnesses, are trying to make it appear as though the witnesses couldn't possibly have identified their clients because they're going to blame the crime on someone else or perhaps on each other. And that is what makes this kind of case so difficult, because in part, at least, it will rely upon testimony from those who generally aren't credible. So the prosecution has to find a way to bolster their credibility and to prove through other witnesses and physical evidence that those witnesses are credible and they're telling the truth.
Yeah, it's going to be an interesting trial to watch. It just started today, and we have another case that just started today. This is the Daniel Tate case in Wisconsin, the trial of a 20-year-old who's accused of murder on the beach. The accusation here is that he choked and basically put underwater the head of a 17-year-old named Olivia McKay. My understanding is that the father of that victim is on the stand right now in Wisconsin, so we're going to switch to that case. The Wisconsin murder trial of defendant Daniel Tate. He's accused of luring a 17-year-old named Olivia McKay to the shore of Lake Michigan, where he allegedly put her head underwater and choked her to death. Those are the accusations, and we just listened to a lot of testimony from one of the detectives who recovered text messages and other messages back and forth between the defendant and the victim. Francey Hakes is here on the line with us on the Law and Crime Network. Francey, this is sort of run-of-the-mill detective work these days. A lot of examination of records, cell phone pings, Facebook messages, lining all these different electronic messages up to try to identify a defendant, and that's what happened here.
That's exactly right. And additionally, Aaron, what they're trying to do is make sure that they establish intent to commit the crime, or at least intent to assault the girl. It's clear from these messages that the detective was reading that, state anyway, that he fully intended to engage in some kind of sexual activity with her, and that's part of their theory of the case.
Yeah, I think the defense here is that this was some kind of a sexual thing, a sexual tryst, and that it was just one that went horribly wrong. Now, apparently that was supposed to involve some kind of choking and other sorts of things. Maybe that's how the defense is trying to beat the intent charge here. This is intentional homicide in Wisconsin. Premeditation is not required. Maybe that's how they're trying to beat it. But look, we've got more testimony from the detective, so let's listen in. Questioning there from one of the key witnesses in the trial of Daniel Tate. He is 20 years old, and he is accused of killing a victim, Olivia McKay, intentionally. Now, we heard from that witness that cell phone chats and other Facebook chat records were collected that indicated that the victim, Olivia McKay, agreed to meet up with Tate and a friend, and there it seemed like the defense was trying to get the detective to say, hey, wait a minute, you didn't look into what was going on with his friend enough. Is it possible that the defense is trying to point the finger just a little bit at this friend? And I wonder whether or not that friend meets the Denny parameters in Wisconsin. That's State versus Denny, a case that says if you're going to name another suspect, that other suspect needs to have had the means, the motive, and the opportunity to commit the crime rather than the defendant. It's interesting because the state doesn't have to prove motive when the state goes after a defendant, but a defendant in Wisconsin has to prove motive if the defendant is going to name someone else. It looks like they're going to call yet one more witness in this case in Wisconsin. I'm curious to see exactly how late they're going to run. This is one of two cases that we're covering here on the Law and Crime Network. The other is the Kwame Richardson and Henry Hayes case out of Florida. There, the accusation is that in a gang-related shooting, those two defendants actually caught a 22-month-old toddler, Aiden McClendon, in the crossfire, killing that toddler when the accusation is that they were really after that toddler's cousin. We're keeping an eye on that courtroom. The lead detective is on the stand in that case. Again, if you'd like to watch any of the raw feeds that come into us here at Law and Crime, you can go to lawandcrime.com, and there you can click on whatever trial you want to watch. But in the meantime, perhaps one more witness in the Tate case in Wisconsin, so let's listen. Again, we're in the Daniel Tate murder case from Wisconsin. The accusation there is that a 20-year-old man lured a 17-year-old woman to the beach and killed her there. Francey Hakes is with us here on the Law and Crime Network. Francey, I thought the defense asked a pretty good question there, and that is, look, the state is trying to make a link between these bags that were found covering the victim's body and the type of garbage bag that was recovered from the defendant's home. And the defense said, hey, look, don't all these bags pretty much look alike? I thought it was a pretty reasonable question.
It is a good question. I mean, I think the defense has a decent strategy here. They're trying to say that there's just not that much evidence showing you who killed this girl. It could have been the co-defendant, and they're trying to say that through things like when the other defense attorney was questioning the witness about the cell phones. Well, if someone else has access to your cell phone, they can text from your account, and it might or might not be you. And so in that way, they're trying to point out that it could have been the co-defendant. And of course, with the bags, as you note, those bags are very common.
Yeah, I mean, even if they're not made from the same manufacturer, they at least look similar enough for people to say, hey, look, you know, a black garbage bag with yellow handles is a black garbage bag with yellow handles. I mean, are we going to get some kind of a, you know, a test to make sure it's exactly the same kind of plastic or what? You know, I mean, I'm waiting to see if they're going to make a firmer link there. And again, is it relevant? So we're going to come back to court in this Daniel Tate case in Wisconsin. All right, we are at the end of the day in the Daniel Tate case out of Wisconsin. This is a Milwaukee area trial, and the accusation is that the 20-year-old defendant agreed to meet a 17-year-old woman named Olivia McKay near the shore of Lake Michigan, and that in the process of that meetup, which was sexual in nature, he held her head underwater and choked her to death. Francey Hakes is in Los Angeles, California. She's an attorney, and she's joining us now on the Law and Crime Network. Francey, look, the accusations here are pretty heinous. You know, the victim's body was left under some garbage bags. We do know that. But it's a bit of a back and forth here, at least in the defense version of the case, as to exactly who did what. And it looks like what they're trying to do is attack whether or not this was an intentional death or whether it was accidental. Under Wisconsin law, you only need to prove intent. You don't need to prove premeditation. And I don't think it's a secret at this point that the defendant and the victim were together. Is there room for an acquittal if this was an accidental death?
Well, I certainly hope not, because it seems to me that his history that I think we're going to hear about later in the trial suggests that he has a streak of violence. And I think what's interesting about this case, Aaron, there are two things really. One, it's a real cautionary tale for parents monitoring the digital activity of their children. But two, it shows the jury what can be very inconsistent. The defendant is clearly trying to say multiple things that aren't consistent. Either I didn't do it, or I didn't mean to do it, or actually the other guy did it. Those things aren't consistent, but that doesn't stop defense attorneys from trying.
Well, yeah, I mean, when you start adding those all up together, then somewhere in there, the defendant's own words are not going to make him look, or I should say, not going to make the jury look kindly upon him. But it's relatively easy to get a murder conviction in Wisconsin because a lot of states require premeditation and whatnot. Wisconsin does not. Wisconsin makes it really hard for defendants to point the finger at someone else as well. I was saying before that if a defendant wants to name a third-party suspect in Wisconsin, the defendant has to prove that that suspect had motive, but the state doesn't have to prove motive against the defendant. And, you know, that dichotomy was a huge issue in the Making a Murderer cases of Stephen Avery and Brendan Dassey. You know, could a third-party suspect have been brought in? You know, and ultimately it was really hard to clear that hurdle. So if the defense really wants to go there, then presumably they would have had to throw enough up to try to clear that hurdle.
Well, that's true. And I think it's not that hard of a hurdle, though, I think, in a case like this, where you have two people, a potential sexually violent motive, and maybe the evidence isn't quite so clear which person was the one who actually committed the strangulation and held the poor child's head underneath the water. And so you're definitely going to have Tate pointing the finger at the cooperating defendant and saying that it was actually him that did it. And you've seen the defense lay a bit of the groundwork for that now. It'll be very interesting to see how they follow that up.
Yeah, I'm really interested as well. I'm curious to see how this is going to go on. And, you know, look, I mean, I'm speculating here, but we could sort of conjure up a scenario by speculating, hey, look, maybe this thing didn't go the way the defendant wanted it to. Maybe Olivia McKay decided she wanted to back out of this. Maybe the defendant got angry and this did get violent. Maybe that's what happened. And it seems that the state is going to try to paint it that way.
I think that's exactly right. That's certainly what I would have done as a prosecutor. I think it's why they're going to bring in other witnesses to talk about his penchant for strangulation so that they can paint him as a violent sexual predator.
Yeah, well, this is going to be an interesting trial. It's our main trial here on the Law and Crime Network. Francey Hakes from Los Angeles, California, attorney there. I certainly appreciate your perspective, and we'll see you again sometime soon.
Thanks, Aaron.
Okay, just to remind folks, the Florida case of Kwame Richardson and Henry Hayes is continuing at this hour. We are not sure how late that trial will run, but one of the lead investigators is on the stand right at this moment. We're keeping an eye on that trial, but we're not going to cover it here on the Law and Crime Network. So if you would like to continue watching it, you can go to lawandcrime.com, click on the live tab, and there you can see the raw feeds of all the cases as they come into us here at Law and Crime. And of course, if you're not on the website, you can certainly watch all those raw feeds on our mobile app. So we will see you back here tomorrow starting at 9 in the morning. For now, this is Aaron Keller, and for everybody here at Law and Crime, have a good evening.